Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again, and we are back with a new video on your legal affairs for your CLAT and AILET 2022. As we've been trying to cover a lot of legal affairs during our time when we have started preparing on this channel itself. So there are a lot of videos that you can look into, and please don't forget to hit on the like, share, and subscribe button if you are new to the channel. And if you don't know that we have a Telegram channel also, you can be a part of a Telegram channel too. It is under the name of CLAT@Pratham also. So you get all the free updates, you get all the free sessions that are there. Any law school admissions notifications that are there are always uploaded on that channel also. So you can definitely become a part of it by just going on Telegram and subscribing to the channel. Okay. Now, what is the first legal affair for the day? Right. So the Karnataka High Court has banned on online gaming that is considered to be unconstitutional here. Right. So there was a division bench that was being headed by Chief Justice Ritu Raj Avasthi and Justice Krishna S. Dikshit. Now, according to the bench, Karnataka Act number 28/2021 to extend the provision ultra vires the constitution, however, not the entire act. Now, there was a judgment that was interpreted for preventing an appropriate legislation concerning the subjects like betting and gambling in line with the provisions of the Constitution. A writ of mandamus, was issued to restrain the respondents from interfering with online gaming business and allied activities of the petitioners. So ban on online gaming is considered to be unconstitutional. This is what the Karnataka High Court has said, but they were trying to curb the malice of betting and gambling that we have seen that Karnataka High Court has put a ban on online betting and gambling. So that is why Karnataka High Court plays a very, very important role in such a case. And they have said that banning online games is something that will be considered ultra virus. That means that it will be going outside the power and acting. So that is why it is considered ultra virus to the Act of Karnataka. Karnataka Act number 28/2021. Now coming to the next case for the day, that is clear case of general bias is being seen by MP High Court. They says that the policy to not consider sister or married daughter for compensate appointment as unconstitutional. So compassionate appointment means when someone is on duty and they passes away, so the person who's the next hire gets the job. Now, the Madhya Pradesh High Court has recently held that the policy of National Coal Wage Agreement to not consider sister/married daughters for compassionate appointment is a clear case of gender bias and is thus unconstitutional. ठीक है जी, वो कह रहे हैं कि अगर ऐसा कोई चीज की जा रही है जिसके अंदर उनको उनकी जेंडर रोल की वजह से बोला जा रहा है कि they can't be a part of this compassionate employment, then it is a complete gender bias case. So definitely they have declared is as unconstitutional. Now coming to the next part is that Justice S.A. Dharmakari was essentially dealing with a writ petition, where the petitioner was aggrieved by the order passed by the respondent company, whereby they rejected the application for grant of the compassionate appointment to the daughter because she was married. Now that is why the court has said that it is under the spirit of Article 14, 15, 16 and 39 that there should be no gender bias in this case and they should be given compassionate appointment, right? So definitely if a person dies on duty and they have a married daughter or a sister, then definitely they can also apply for compassionate appointment and it will not be rejected just because they are married, or they're females, right? So it was considered that this was a gender bias rule that was being created and it was not in the spirit with the article of 14, 15, 16 and 39 of the Constitution of India. Now coming to the next part, that is that the courts are slow in interfering in religious matters. That is what the J&K Legislation High Court PIL against religion sacrifice of animals right? So we have seen that Bakra Eid, there are a lot of places where goats are being sacrificed. There are a lot of places where camels are being sacrificed. There's a lot of religious practices that is being done. Now there was a Jammu and Kashmir and Ladakh High Court recently rejected a public interest litigation that was seeking prohibition on the illegal practice of slaughtering animals on the basis of superstitions and in the name of religious sacrifices. Okay, but with this, the Chief Justice Pankaj Mittal and Justice Sidhu Sharma also noted ordinarily that the courts are always slow in interfering in religious matters or with the sentiments based upon religion or in a practice of any community. Okay. Now there was a plea that was moved by Tek Chand in the capacity of public spirit pujari of Hindu temple for a direction to declare Section 28 of the Prevention of Cruelty of Animals Act 1960 as unconstitutional. Okay, and noted that Section 28 of the Prevention of Cruelty to Animals Act provides that nothing contained in the acts shall render it to an offense to kill animals in a manner required by the religion or any community. Okay, which practice of slaughtering or sacrifice animal is illegal or illegal depends upon the traditions and custom of particular religion and the place of worship. It is the matter of evidence which cannot be appreciated in the exercise of discretionary jurisdiction. Okay, so it is clearly said that the courts are slow in interfering in religious matters because there are a lot of things that are involved, and here they were discussing the cruelty of animals. Now you know that the Prevention of Cruelty of Animals Act came under the law in India in under 1960. Okay, so it's established from 1960. So you can see it is a very fairly old law, and also there are a lot of matters that are related to the protection of these animals also from illegal slaughtering, and there have been a lot of laws from different states that are there. As you can see, this is also a kind of a religious thinking that is being portrayed in this kind of a PIL that is being filed, but that's what common in our country and their courts. Now coming to the next part is that this is an observation given by the Kerala High Court, is that if the wife is making frequent discreet phone calls to another man, okay, at odd hours, despite husband's warning, is matrimonial cruelty. Okay, very interesting, but yes, that is the observation of the Kerala High Court. Now here the Kerala High Court has given the decree of divorce to the couple and ruled that phone calls that were made secretly by the wife to this man, ignoring her husband's warning against the same amounts to matrimonial cruelty. There was Justice Kausar Edvika, who was in this judgment observed that mere compromise would not amount to condonation of cruelty unless and until the matrimonial life was restored. Now, making discreet phone calls frequently, that too at odd hours, amount to matrimonial cruelty that the court has held. That is why they were able to provide them with appropriate jurisdiction and provide a decree of divorce to the couple. Okay. Yes, Mayor, this is a class for legal for CLAT only. Now, marriage certificate not necessary for adoption of a child. This is what the Allahabad High Court has said in a transgenders persons plea seeking marriage registration. Now, the Allahabad High Court has observed that for adoption of a child, a marriage certificate is not a sine qua non, and even a single parent can adopt a child under the Hindu Adoption and Maintenance Act of 1956. So there is no marriage certificate required, and even a single parent can adopt it. Agar koi akela aadmi bhi adopt karna chahta hai child ko, that is definitely possible. The bench of Justice Dr. Kushal Jatendra Thakur and Justice Vivek Verma has observed that while dealing with the plea of this transgender husband, a person and her husband who sought a direction upon the sub-registrar Hindu Marriage District Varanasi to consider and then decide the online application for marriage filed by them. ठीक है जी, तो कोर्ट ने बोल दिया शादी करने की कोई जरूरत नहीं अगर आपको एक बच्चा अडॉप्ट करना है. So that is what the court has said very straightforwardly. Okay, now coming to the last news for the day, that is that might not be the last, the second last. New York Supreme Court allows Attorney General to compel deposition of Trump. says there is a copious evidence of financial fraud. Okay, so now what is happening that the Supreme Court of New York has on Thursday quashed Donald Trump's and his children Ivanka and Donald Trump's Jr. motions against the subpoenas issued by the New York State Office of the Attorney General. Okay, now the judge Arthur Irgon has refused to stay the parallel civil investigation instituted against them and ordered Donald Trump to come and comply with the subpoena seeking the documentation and information to appear for deposition within 21 days. Ivanka and Donald Trump Jr. have also been ordered to come for a deposition in 21 days. So now you can see that there are a lot of things that are going on for the Trump family in the New York Supreme Court, and definitely there will be a lot of news that will be coming after the deposition is done within these 21 days. Right, so you can see that the president is also being asked for a deposition, ex-president. So definitely there are a lot of things that need to be known by the country of United States of America, because there were a lot of things that have happened during this time after COVID. So definitely that will lead to a lot of changes that you will see in the coming politics of United States of America also. Now coming to the next news, that is that remote chances of the child survival or leading a normal life. So if there is a chance that the child that is going to get born is not going to lead a healthy life and will not be able to survive for long, so definitely the Calcutta High Court in such a case has allowed for a medical termination of approx 35 weeks old fetus. Can you imagine? Almost 9 months old fetus. He was allowed to go ahead with that. And you know, under the medical termination of pregnancy that we have discussed, the limit for termination is from 20 to 24 weeks, right? So definitely there is, if there are certain circumstances where things of this sort come up in front of the court, then definitely they allow medical termination of pregnancy. Okay, so these are the important current affairs for this week. Then you can definitely give us a call on 5 times 9 75392 if you are looking for any personalized counseling, and if you are looking for any mentors. Right, we provide you mentors from national law universities all across the country: Nalsar, Hyderabad, Bhopal, Kolkata, Jodhpur. All of the places we have our mentors very well sorted. So you can definitely get in contact with us and also ask about the counseling and mentorship sessions. Right. So thanks for joining this live session. Do take care of yourself and stay healthy. Please wear your mask and hand sanitizers and stay safe. If you are above the age of 18 years, do get yourself vaccinated. And thanks for joining this live session. We'll see you all again on Wednesday with a new video. And please drop in the comment box what all videos do you want us to make further. Will be of great help. Thank you guys. Bye-bye. Take care of yourself and stay safe and stay healthy and keep preparing.